that I mentioned. That brings us to a presentation by our city attorney on some of the issues that were raised in the public hearing that we had a couple of weeks ago dealing with the proposed human rights ordinance. Ms. Grinzinger, did you want to make any comment before
Just
the
very
presentation?
briefly, and to reiterate what the Vice Mayor said, a public hearing was held on a draft human rights ordinance at the last commission meeting. At that ordinance, a number of questions were raised by people in the audience about the potential impacts that ordinance may have. Another concern was raised as to whether the definition of religious organization in the first draft accomplished what the City Commission really intended. So the Commission asked Mr. Scott to prepare a presentation this evening to address some of the concerns that residents brought to the podium and to take a look at that definition of religious organizations. Once Mr. Smith finishes, the Commission might consider postponing the action they had scheduled for this evening to a future meeting. At the May 29th meeting, the Commission postponed action on the ordinance until this evening.
Okay. Mr. Smith.
Thank you. This is a follow-up to the public hearing. As Ms. Grinzinger indicated, there were some 48 people who spoke at the public hearing. Others wrote in and commented. Some called in with comments. We appreciate the thoughtful and respectful discourse. We listened carefully and thoughtfully to all of the concerns, and at the end of that meeting, as she indicated, you postponed action to address those concerns. We're going to address the questions and comments. Some comments led to a suggested language change. Some comments were based on misperceptions. Some comments were more questions, and so we're going to try to answer those questions. We have to organize it in some way, so I'm going to speak about the enforcement or administration questions that came up, the religious liberties questions that came up, and some questions that came up about public accommodations. And you'll see things rather loosely organized in that fashion. First of all, there were questions about other communities that have the ordinance. There were some in the audience who thought that there were very few communities in Michigan who had a similar ordinance or an ordinance addressing similar issues. There are, in fact, 18 communities that have a similar ordinance. We contacted most of those communities. And that led to some questions about enforcement concerns. Some asked if we had sufficient staffing and resources to enforce an ordinance like this. And that was a question that the Commission asked early on and that we addressed in some previous presentations. But other communities have experienced very limited complaints. Most of them have had 1 or 2 complaints a year. Many of them could not recall any complaints. The need for extensive investigation and enforcement has been nearly non-existent. Rarely have they consulted with the city attorney, and nobody reported any court involvement. In addition, our ordinance gives administrative discretion for enforcement and investigations, and I'll talk about that a little more later on. There are a number of enforcement provisions in the ordinance. First of all, if the alleged violation constitutes a violation of a state or federal law, our ordinance requires that that matter be referred to the appropriate state or federal agency. Secondly, the city manager will have 4 enforcement options. The city manager may investigate or delegate it to staff members for investigation. It could get referred to the city attorney or other officials to issue a municipal civil infraction citation. It could be referred to conciliation or mediation, or in an appropriate circumstance, the complainant may be notified that the city won't act for a variety of reasons. Again, I'll give some examples of these. If the city chooses not to enforce the ordinance and there's a violation of the ordinance, or if somebody thinks that the city's made a wrong determination there, there's the possibility to file a private lawsuit under the ordinance. There was a question about whether the city would be selectively enforcing the ordinance by handling or addressing only those issues that aren't also violations of state or federal law. In the first place, that's really not selective enforcement as we would consider selective enforcement, because all we're doing is following the ordinance's own guidelines and requirements at that point. So that's not selective in that we're choosing to enforce the ordinance in some situations and not in others. Secondly, it makes sense to defer to state and federal agencies that are already equipped to handle these kinds of issues when it comes to employment, public accommodations, and housing with respect to racial discrimination, gender discrimination, and so forth. All we're doing is adding to that. And it's a common practice already for local governments to defer to state and federal agencies on a number of law enforcement efforts where you're talking about felonies and other kinds of crimes, where you're talking about statewide task force, sometimes narcotics violations and so forth, and certainly with a number of environmental issues, that's usually left to the DEQ or the EPA to enforce. There were questions about whether this can really address discrimination and whether the ordinance has any teeth to it. We think it can address discrimination in a number of ways. In the first place, assuming it's possible and both participants are willing, we would refer the matter to a conciliation service or a mediation service to try to address issues with complainants and violators in a way that works it out to their mutual best interest. But the ordinance also has teeth. There can be a fine of up to $2,500 for each violation of the ordinance, and if the person has a license issued by the city, the person violating the ordinance, that city license could be suspended or revoked. There was a question about whether the definition of discrimination in our ordinance would, or our ordinance draft would make enforcement difficult. And it's an identical discrimination used in, definition used in state and federal laws. So to the extent that state and federal governments have been successful in using that term and that definition, I assume we would be too. I'd like to give you some examples of enforcement and some hypothetical situations that might arise that would lead to up to 4 different determinations as to what we would do. Let's take an example of a job applicant who responds to a newspaper ad. He calls, is invited for an interview, shows up for the interview, and is told that the job's no longer available. The person is African American and believes that he or she has been discriminated against because of race. They file a complaint with the city. In that circumstance, because it's a alleged racial discrimination not based on sexual orientation or gender identity, the city would simply refer it to the appropriate state or federal agency to address that alleged discrimination. A second example, we have someone who wants to rent a bike from one of our bike shops in town. He shows up, he's 7 feet tall, and they don't have a bike to ride that will fit him. And he makes a complaint because they're unable to accommodate his size at this public accommodation. Unfortunately, our ordinance does not address height and weight discrimination, and so the matter we would simply tell him it's not covered by the ordinance, and that would be the end of that matter. A third example, an out-of-stater, somebody who lives out of state, inherits a house from his or her deceased mother. The house is located in the city. They wish to rent the house for a period of time until they can conduct an estate sale and do something else. A gay couple asked to rent it, and this out-of-state landlord says, nope, I'm not going to do that. We contact the landlord and say that's a problem, it violates our ordinance. The landlord's very apologetic, said, gee, I'm sorry, didn't mean to do that. Mother was a very conservative person, and we thought it would dishonor her to rent the house to a gay couple. We would certainly reconsider and so forth. Such an example might be a case where conciliation or mediation would be an appropriate remedy, where both parties are willing to come together and address the issue. Let's take another example. Another housing example. The applicant wants to rent an apartment. The owner of this particular apartment has a number of different properties in town. It's a gay couple that shows up to view the apartment. The landlord not only refuses to rent to this couple, but then very loudly and very publicly in front of others boast about denying that opportunity, using a number of epithets and slurs, and has a very public display of animosity. A complaint gets filed, the city investigates, we determine this isn't the first circumstance where that has occurred, and determine that this landlord has been, had other incidents, similar incidents, and so we may, at that point, decide to issue a civil infraction notice or citation, or we may even decide to take action to suspend or revoke his rental housing license. There were a number of questions asked about religious organizations and institutions, and some were saying that the city's imposing a value system and compelling people to act contrary to religious values. I can only say that some of the same concerns were voiced on racial and religious discrimination prohibitions a generation ago, and more recently have been raised in connection with housing discrimination requirements related to marriage and families and so forth. This ordinance simply extends to gay persons protections afforded to unmarried heterosexual couples, interracial couples, and so forth. Nothing in the ordinance affects the right of anyone to advocate their beliefs, but it does impose some requirements in the marketplace, similar to the requirements imposed in the marketplace, prohibiting discrimination on other bases. There was a question about whether a church can limit the use of its facilities to those conforming to its religious tenets. And yes, that's very expressly provided in the ordinance. I direct you to a section that we debated at some length, and it says that a religious organization or institution may restrict the occupancy of any of its housing facilities or place of public accommodations operated as part of its religious activities to persons of its denomination or those who conform to the moral tenets of that religious organization or institution. We then added a sentence that says that this exception shall apply to a religious organization or institution that allows persons other than its members to use its facilities if its facilities remain exempt from Michigan property taxation pursuant to state law. So this addresses the situation where a church or other religious institution allows somebody to use a recreational hall or some other part of the facility for a wedding reception or other use on occasion, even if they're not members of the church, as long as they don't do so to such an extent that they would lose their property tax exemption. Now, there was another question that was raised, and here's where we changed or are suggesting a change in language from the draft that was available prior to the public hearing. There was a question about whether our definition of religious organization or institution would protect agencies such as the Salvation Army and Love, Inc., who don't really teach religious tenets as much as they provide charity to the community. And what we've done is make it clear that a religious organization or institution includes one that not only seeks to inculcate religious values, or it provides charity, and we added a sentence to address that. Religious organization or institution includes, for purposes of illustration and not limitation, churches, mosques, and synagogues and other houses of worship, any subsidiary organizations, so they could run a soup kitchen or something else as a subsidiary. Educational institutions affiliated with, controlled, or managed by those houses of worship, or with articles of incorporation, bylaws, or other documents stating an intention to inculcate its religious tenets and students, so it covers Christian schools, and faith-based organizations that, due to a sense of duty based on particular religious tenets, provide charitable services to the public. So this should address the issue for both the Salvation Army and Love, Inc., and we appreciate the comments pointing out that concern so we could make the change. There were public accommodations concerns. Some were saying that this may force businesses to serve customers they don't wish to serve. And again, I want to point out that a generation ago, similar concerns were raised about prohibiting racial, gender, religious, and other discrimination. We can all remember the pictures of the lunch counters where African Americans weren't served. The ordinance simply extends the same protections to sexual orientation and gender identity as state and federal law do now for those other areas of discrimination. There was question about what a private club consists of. It's an establishment not open to the public whose members' association with each other in the club is sufficiently intimate, small, and exclusive, and it can even be something like Augusta National Golf Club is a private club and treated that way under federal law. That's why that even though they have the public accommodation of the Masters tournament, they can still limit membership to males.
Unfortunately.
And there was a lot of discussion about that at the last Masters coverage. There was a question about what the effect might be on the Boy Scouts' use of public facilities. And again, I think it was born out of a misperception. We have a provision in the ordinance that says the chapter shall not prohibit the city from allowing use of its facilities or services by persons that may be affiliated with or otherwise supported by a religious organization or institution that may espouse policies inconsistent with the city ordinance, and it won't prohibit the city from allowing use of its facilities or services by persons not generally affiliated or supported by a particular religious organization or institution, but who espouse policies or practices inconsistent with the general intent of the chapter. So the Boy Scouts, who have previously restricted at least leadership roles, would be allowed to use city facilities, parks, and so forth. At least this ordinance wouldn't prevent them from doing so.
Did we skip over the?
There was a question raised about what the impact might be on a graduation or commencement speaker, and the persons referred to the coverage that the Sacred Heart Academy engendered. First of all, in that situation, no one was prevented from attending the event. The question was whether the speaker would be allowed to speak. So because speaking's part of the program, it's not a housing, public accommodation, or employment concern. Sacred Heart of Mary is also an educational institution under the aegis of the Catholic Diocese of Saginaw, and so that religious exception that I spoke of earlier that would deal with educational institutions affiliated with churches would cover it, and so Sacred Heart of Mary would remain free to select commencement speakers based on religious beliefs. And the same would be true for any other religious institution. There was a question that came by email regarding the Central Michigan Pregnancy Services. That we did some research on. It's a 501c3 organization incorporated as a Christ-centered ministry to uphold the sanctity of life. It would not be affected by the ordinance. If it's an employment issue, it would likely be a faith-based employment issue and subject to state or federal law and would get referred to and handled in that kind of fashion. If it's a public accommodation issue, I'm not sure how it would come up in the context of a person with a sexual orientation or gender identity discrimination, but this ordinance wouldn't apply to it anyway because it is by its articles of incorporation, a faith-based institution. A quick recap. We value the public input. Hopefully the public sees that as a result of that input, at least one change was made in the ordinance. This ordinance does not affect anybody's advocacy rights. I know that there are persons who are looking to Canada and to other countries where some anti-discrimination laws have gone to the point where they infringe on advocacy rights, and this ordinance doesn't affect that at all. Neither does it require or allow preferential treatment. It allows religious organizations to engage in employment, housing, and public accommodation practices consistent with their tenets, and it's a shield, not a sword. That is, it can't be used to require anybody to do anything. It just shields somebody from discrimination. And with that, I'll address any questions.
Do any of the commissioners have any questions? Commissioner Jocelyn.
Yes, Scott, thank you for your presentation. That was extremely educational, and I really appreciate it. One of the examples that I continually get from businesses is the idea that a gay couple would be misbehaving in a store or a restaurant. And the biggest fear is, if a heterosexual couple was doing the same thing, you'd ask them to stop or leave. But now there's this overlying fear that because it's a gay couple, that now if we ask them to leave, we're discriminating. And I'm having a tough time explaining that to people, that you still have the right to operate your business equally. But again, there's the fear that, well, it doesn't matter because there's always that perception. Can you address that a little bit for us? Because I'll tell you what, I have a tough time explaining it to some of the business owners.
Yes. Well, as a youth group leader for my kids used to say, they said, no PDAs, no public displays of affection, right? And if the behavior is such that it's offensive, whether it was by a gay couple or a heterosexual couple, as long as they're treating people the same and that the gay couple's not getting treated differently because they're gay, then they're free under this ordinance to exercise their judgment in their business accordingly.
But I guess
So
the
if,
further question that I get is, where does the burden of proof come then? Because the business owners can say, hey, this is the way I treat everybody. Do they have to prove this is the way they treat everybody? Or does a person complaining have to prove that they don't do it that way?
Well, before the city could issue before the city could, if it's a civil infraction, for example, or before the city could, if it's a civil infraction, the city has the burden of proof by a preponderance of the evidence that the civil infraction occurred. If we were to take license action, we would have the burden of proof to show that the business actually violated the ordinance. So it would be our burden of proof if we were to take the enforcement steps that are available. So before a fine could be imposed, before a license could be revoked, it would be the city's burden of proof.
Okay, that's a great way of saying it, I think. Thank you.
John?
Yes.
Just, I want to back
ahead.
up one more step to that same question. Before the city could take any action, isn't it the burden of proof of the complainant coming to the city to prove that that business owner was treating them differently? I mean, the conversation that exists initially, the burden of any of these is on the complainant that they were treated or discriminated against. Then the city would have their first decision if they're moving that up into an enforcement process.
Well, I suppose in that way, it would be like anybody complaining about the activity of any business. If somebody were complaining that a landlord was violating our rental housing ordinance, or that somebody was violating the fire code, or somebody was making a complaint that there was, their neighbors were, had their stereo turned up too loud, it would be, we would treat it in the same kind of fashion. So this ordinance doesn't impose any less of a burden on the complainant or any more burden on the complainant than any of our other ordinances would for a complainant.
Thank you.
Commissioner Jocelyn.
Just flipping through, I made notes on your slides as you went through. My next one is just a comment on the religious facilities questions. Every time I read it, I hate giving you a compliment, but I'm so impressed with the idea that you tied the taxation, that as long as they are using their facilities in a non-tax manner, that they continue. I think it's such a great way of tying it.
I think that idea actually came from commissioners, but
Congratulations, which commissioner came up with it, 'cause it's a brilliant way of putting it. My next question was on one of your very last comments or slides, and that was the pregnancy centers, and you referenced articles of incorporation, and that makes me nervous. Is it any articles of incorporation or just nonprofits? Can any new business go out there and all of a sudden in their articles claim that they're faith-based and be exempt from this, even though they're not faith-based? I mean, I don't think people would necessarily do that, but you got to think all the consequences and all the avenues.
well, as I said, this is a 501c3. It's not only nonprofit, but it's tax exempt. And so it's a charity that provides these services at low cost or less than cost. And we're not looking at a business at that point. We're looking at a charity or a religious institution.
Okay. Thank you.
Any other questions from commissioners? Commissioner English?
Just a couple things I'd like you to clarify or speak to. You mentioned this isn't giving any preferential treatment. I think that's something I hear once in a while about, correct me if I'm wrong, but this isn't about needing to hire any particular person.
No.
It is about not being able to fire someone for a particular reason. And then to go along that line, one of the frivolous examples I'd like you to just speak to is, I have a lot of questions of the same as Commissioner Jocelyn, but in the employment area. So I fire someone, and the concern is now, because that person might be gay, I'm fearful that I'm going to get a lawsuit that I fired them because they were gay. But obviously, so the scenario might be, we have a poor employee that has had a 3-month improvement plan and has had several incidents and then gets fired and also happens to be gay and then brings to the city a complaint. So if we would just kind of address how that would go.
Well, I'm assuming the employer would treat this in the same fashion as I would counsel an employer to treat personnel practices or personnel decisions regarding a woman or an African American or a Islamic employee or any one of a number of other classifications that are protected under state and federal law, because we would look at it in an identical fashion. So as long as you're using an appropriate personnel practice, and it would pass muster if the person fit in any of those other categories, you don't increase your risk here.
Okay.
Can I follow up?
Sure. Mr. Jocelyn?
But some of the concern is the fear of increased cost, increased that now all of a sudden they have to defend themselves yet another time. And you're just saying as long as their policy is consistent, I mean, it's, even though the policy is consistent, there's that underlying fear of the business that, yeah, they've already got to deal with this, with racial issues, that if they fire anybody of an off race, whether they've got this policy or not, there's always going to be the possibility that, you know, it's, that they've been accused. And now they have to hire an attorney, now they have to go to court, now they have to incur the cost to defend their position, which is obviously laid out. And are we adding one more layer to that?
I don't think we're adding a layer to that. We're simply adding, we're protecting another class of persons from discrimination. So again, whether it's age, whether it's religion, whether it's gender, whether it's race, whether it's national origin, there are a number of classes of characteristics of folks that you need to deal with, and as an employer, make sure that your policies and practices fairly treat all of those folks. And this is just another classification that's added to that, and another prohibited reason for hiring or refusing to hire or firing or taking other disciplinary action. It's not, it shouldn't be an excessive burden. I mean, theoretically, employers are treating all people fairly now.
Commissioner English.
My last question to your presentation, you had mentioned a scenario where someone were renting a house, and I just wanted to clarify, because in this ordinance, we do make some exceptions for, I'd like you to speak to them, someone who lives in one half of a duplex but has the right to rent the other side. So I didn't want that one single house to confuse people. So could you address a couple of those scenarios?
Right. There are a number of housing exceptions. If you're looking for a roommate and you're living in the apartment as well, if you're renting out a room in the home you live in, if you're in a duplex and renting out the other side of a duplex, the ordinance doesn't apply. The example I gave was somebody who didn't live in the home that was being rented, and it was specifically set up that way. I probably should have pointed that out with the example. Good catch. Good question.
And if you maybe have a home with an apartment on your property, one single
Right.
apartment or a garage, that fits under the exception as well.
It does.
Thank you.
Any other questions from any of the commissioners? If not, I'd like to thank you very much, Mr. Smith, for your presentation. I think it was very clear and very helpful in addressing a number of the issues that came before us 2 weeks ago.